Good afternoon. Welcome to V&E's Energy Industry Series of CLE programs. I'm Jason Powers. I'm a partner in the Complex Commercial Litigation Group here in Houston and one of the co-heads of the firm's Antitrust Practice Group. Today we'll be talking about the report, the Chemical and Energy Antitrust Report that we've released this year. We'll be discussing what energy and petrochemical companies need to know about what's happening in antitrust and what we're expecting from the new administration, how the new regulatory team will be reviewing deals, as well as what's happening at the courthouse. We do have a lot to talk about today, and I'll be speaking with you later in the hour about what's happening on the litigation front in antitrust. But we have a new administration, new leadership at the agencies, new enforcement priorities, and a new environment for companies that are looking at major transactions. So naturally, we turn to Washington, and Darren Tucker from our Washington office is going to lead us through some of those issues. I had expected Darren would be standing next to me right now, but there's been 7 inches of snow in D.C. in the last 24 hours. And given that this office had to shut down for 2 days over less than half that much snow, I'm not going to begrudge him being unable to get to the airport today. So Darren has been practicing in the antitrust space for 25 years, both in private practice and as counsel to the Federal Trade Commission, where he directly advised commissioners on enforcement and policy issues. Today, Darren works with clients in all aspects of antitrust, whether they're engaged in transactions that are going through antitrust scrutiny or facing government investigations either at home or abroad. He's also served as an adjunct professor of antitrust law. He's been an officer of the ABA Antitrust Law Section and was the editor of the 8th edition of Antitrust Law Developments, which is the indispensable treatise in the antitrust bar. So, Darren, why don't you go ahead and get us started?
Great, thanks so much, Jason. It's a pleasure to join you all. And as Jason alluded to, I apologize I was not able to join those of you in our Houston office today. I was hoping to make it, but Mother Nature had other plans for me. I'm going to focus today on what to expect for antitrust enforcement in the Trump administration. And I'm going to approach this in a few different ways. We'll talk first about new leadership at the Federal Trade Commission and Department of Justice. Talk about what we expect will be the new enforcement priorities under the Trump administration, what we can expect in terms of enforcement level. So will they dial up, dial down the number of cases they bring, and then briefly talk about some holdover issues from the last administration. For any of you that have heard this program in years past, usually we do kind of a look back at the previous year, but because of the change in administration, I'm really going to have much more of a forward-looking discussion with you all today. So what to expect in the new administration. So let me just start with the basics. So as probably you all know, we have 2 primary federal antitrust enforcers. We have the Federal Trade Commission and the Department of Justice. They are organized differently and they have slightly different enforcement mandates. At the FTC first, so they are governed by a 5-member commission, and only 3 of which can be from the same political party. Over at the DOJ, it's a little different. It's one person who leads the antitrust division, who's an AAG. And in terms of their enforcement, obviously both are enforcing the antitrust laws, but they tend to divvy up their work in a certain way. We call that clearance in the industry. So over at the FTC, they're responsible typically for oil and gas mergers, coal mergers, whereas DOJ handles oil field services mergers. And in addition, DOJ handles all criminal enforcement, regardless of the industry. So new leadership of the agencies will have obviously a big effect on what we'll see over the next 4 years. It typically takes a while to get new leadership in place at the antitrust agencies. I'm sure you've all seen in the news, there's a lot of nominations, there's a lot of confirmation process going on in various committees in the Senate, votes on the Senate. And we've seen a number of President Trump's nominees already go through that process at state, defense, other agencies. It takes a little longer for the antitrust folks to get through that process, simply because it takes a lot of time to get these folks through, and any administration has certain priorities. And the antitrust agencies are a little further down on the list. So historically speaking, it's taken about 4 to 6 months to get new leadership in place at the 2 antitrust agencies. I think it'll be a little bit faster with the current administration. They're just moving the process along a lot more efficiently than what we've seen in other administrations, including the first Trump administration. So, for example, we did a little analysis and found, after the election, then, Mr. Trump nominated or announced nominations twice as many within the first month as in the prior 3 administrations, including his own first administration. So things are moving a lot faster this time. So he has nominated Gail Slater to head the DOJ Antitrust Division. She is well known in antitrust circles. She's been involved in antitrust and related policy issues her entire career. She was most recently economic advisor to Vice President Vance. She was White House National Economic Counsel during Trump's first administration. She was an FTC attorney for 10 years. I overlapped with her there. We actually had the same position at the agency. We were both advisors to commissioners. So we actually interacted quite often representing our respective commissioners. She's also been in private practice. She worked at the Internet Association, Fox, and Roku. She actually has her Senate Judiciary Committee hearing today, which I think will be very interesting to hear, what her enforcement priorities will be, as well as just her general approach she intends to take to her new position. She's been relatively quiet in terms of her enforcement priorities. When her nomination was announced by the president, he indicated that she was going to be very tough on the tech industry. So I think there's widespread expectation that the current aggressive approach from both the FTC and DOJ against the tech industry is going to continue. But otherwise, we've not heard a lot else from Ms. Slater in terms of her views on the energy sector, for example, or other aspects of antitrust enforcement. Over at the FTC, again, this is where we have a 5-person commission. President Trump has already designated Andrew Ferguson as chair of the FTC. That was made effective on January 20, on the day of inauguration. And the president was able to do this because Mr. Ferguson was already an FTC commissioner. So the president can designate an agency chair by executive order, at any time. And so we do have a new Republican chair of the FTC. He was been a commissioner for about a year. He joined the FTC about a year ago as a commissioner. Before that, he was the Solicitor General of Virginia for a couple of years. He worked with Senator Mitch McConnell on the U.S. Senate Judiciary Committee. And unlike Ms. Slater, Mr. Ferguson has actually been pretty vocal about his enforcement priorities. He was actually quite vocal in campaigning to become the next chair of the FTC, to be designated. And so he put out a number of policy statements in terms of his enforcement priorities. I've added a few quotes to the slide there you can see. But I think maybe top of the list is he really wants to reverse a lot of the policy initiatives of the last administration. Under Lina Khan at the FTC, Lina Khan was the previous chair. The FTC made a number of policy changes in terms of their enforcement approach, took a much more expansive approach to policy, which I'll talk a little bit about later. And Mr. Ferguson has indicated he wants to really reverse a lot, if not all of those. He's also indicated he wants to make the merger control a little less burdensome for parties. But at the same time, he's indicated a strong desire to continue a very aggressive enforcement against tech companies. And along those lines, he's actually indicated a little bit of a break from the previous administration. He wants to use the antitrust laws potentially to go after tech companies for what he views as censorship of conservative views, which would be, I think, a novel use of the antitrust laws. So I think with that exception, I think he's likely to largely revert back to more traditional theories of harm, more traditional sort of bipartisan approach to enforcement. One thing I'll mention is that the other Republican commissioner, Alyssa Holyoke, has also spoken out in favor of this aggressive, sort of novel approach to tech enforcement that he seems to share. Chair Ferguson dissented in a couple of very notable energy enforcement cases last year. The FTC sought consent decrees in the Exxon Pioneer and the Chevron Hess deals. Those were, again, very novel theories of harm. I think that raised a lot of eyebrows. And he dissented from both of those cases. So he did not support the FTC's enforcement on either of those. Chair Ferguson has, announced a number of other folks to, come into his management positions within the agency. These are people that kind of run the agency day to day. I won't go through them all, but I'll just highlight one because I think it may be instructive for what we may see from his leadership. He named just a few days ago Daniel Gornera to head up the Bureau of Competition. And this is the group that basically runs, the merger review process, the civil litigation at the FTC on a day-to-day basis. And these historically have been usually pretty high-profile private practitioners. Sometimes folks have come in from academia that have, some private practice experience. Mr. Gornera instead actually came over from the Department of Justice, where he was the head of the Civil Conduct Task Force. This was a group that essentially leads, civil litigation matters at the DOJ Antitrust Division. And he was involved in bringing cases against both Google and Apple on antitrust grounds. So you can, again, sort of see this sort of pattern of folks at both agencies that have this record of bringing cases against, or at least raising concerns against, big tech companies. Mr. Gornera doesn't really have a lot of a paper trail in terms of his enforcement views. So I think it remains to be seen exactly what approach he's going to bring to his new position. So I mentioned the FTC is led by a 5-person commission. So Chair Lena Khan, previous Chair Lena Khan, departed the agency effective January 31, which left a 2-2 split. So we now have 2 Republicans, 2 Democrats at the FTC. And that really limits Chair Ferguson's ability to advance his agenda. For any decision by the FTC, there needs to be a majority vote. So for any action at the commission level, there will need to be at least 1 Democrat to support any vote that Chair Ferguson initiates. So to fill that open slot, President Trump has nominated Mark Meador as the 3rd Republican to sit on the FTC. He has, again, a very strong antitrust background. It's, I think, a little unusual for a Republican nominee. He spent 2 years most recently in private practice, but is often on the plaintiff side in his work in private practice. He served on the Hill, where he was one of the architects of the State Antitrust Enforcement Venue Act, which gave greater flexibility for state AGs in terms of where they could bring their cases. He was a former Deputy Chief Counsel for Senator Lee, and also spent 10 years as a staff attorney at the FTC and DOJ. So he knows the FTC quite well. To my knowledge, there has not been a hearing scheduled for Mr. Meador. He'll be going before the Senate Commerce Committee for his hearing, but that seems to be moving on a little bit of a slower track than Ms. Slater. So again, until he's actually confirmed, we're going to continue with this 2-2 split at the FTC. So we'll be in this sort of transition mode at the FTC where you'll have a Republican chair, but not a Republican majority. So that will really limit the new chair's ability to advance any kind of significant policy advancement. So turning to that topic, what are the likely enforcement priorities, of the new leadership at the FTC and DOJ? This is a little bit of, reading the tea leaves. In some cases, again, they've sometimes put out some detailed policy statements. In other cases, they've been pretty quiet. But I think we're relatively confident of the items on this slide, which I'll walk through. So I think first off, maybe very relevant for this group, is we expect a softer stance on at least upstream energy mergers. So historically, the FTC has not brought a lot of cases involving the upstream energy space, and that's a recognition that E&P companies are basically operating in at least national and increasingly global markets. We're exporting a lot of natural gas and crude oil these days. And so you really have to look at producers around the world potentially as your competitors. And even a blockbuster energy deal like some of the ones we've seen in the last couple of years really don't have very high market shares when you're looking at global production figures. So again, that's why we really haven't seen a lot of activity in the space historically from the FTC, but that really changed quite a bit under the Biden administration. We had at least 8 significant merger reviews involving E&P deals. A number of these resulted in FTC concerns where there actually was a consent decree to resolve the agency's concerns. I think it's likely that we'll kind of shift back to a more historical approach for the E&P space, where I really don't think we'll see the same level of scrutiny. And again, I mentioned already, the new FTC chair did not support the cases the FTC brought against Exxon and Chevron. So I think that's one area where I think there'll be a pretty dramatic change. In contrast, I think in other areas of the energy industry, I'm not sure we're going to see quite as much of a change. So for midstream deals, downstream deals, we really haven't seen the kind of big swings we've seen between administrations as in the E&P space. So, if you're looking at the Biden administration, the first Trump administration, both brought up a variety of cases in the midstream and downstream space, where there's concerns about long-haul pipelines, terminals, wholesale retail, fuel services or fuel stations. Both agencies brought cases in these areas, and at least on paper, don't seem to diverge very much from each other. So I think we're going to continue to see fairly steady enforcement in the new Trump administration, at least in those aspects of the energy space. One other area, the second point on here, I've already alluded to this already. It seems very clear that the second Trump administration is going to continue a very aggressive stance against big tech companies. This really started in his first administration. The DOJ brought a very significant antitrust case against Google. We now have, between the FTC and DOJ, a couple of cases against Google, one against Apple, one against Meta, one against Amazon. The FTC brought a merger case against Microsoft. And this really aggressive scrutiny of these and other tech companies, I think, is very likely to continue. I think we're going to see a return to structural remedies. And this is one of those sort of in the weeds things that actually makes a really big difference when you have a deal before one of the agencies, or you're thinking about a deal that might run into problems. So let me just provide a little bit of context here. So, when you have a transaction that's reportable to the antitrust agencies under the Hart-Scott-Rodino Act, you put in your filing, you wait 30 days, and then if the agencies have concerns at that point, they'll issue what's called a second request. And this starts a very lengthy, in-depth review. And relatively few deals get a second request. At the end of that process, the agency may conclude that your deal is fine and they'll let it go through, which is great. But more often than not, they actually will have concerns at the end of that process. And historically, there were sort of three different approaches you could take to try to resolve those concerns. One would be that the agency would just sue you. They'd bring a case in court, and you'd have to fight it out before a federal district court judge, where the agencies have to get a preliminary injunction to try to block the deal. Another option is parties sometimes just abandon their deals. They don't want to go through the litigation process. It's just going to take too long, too much money. They just don't want to roll the dice at that point. And there can be all kinds of effects on companies when deals are being held up for such a long period of time. So a number of deals were abandoned. And then the middle ground approach is a settlement. Right? The parties can reach a settlement with the agencies. We call it a consent decree, but it's just a settlement like any other. And this historically was the main way most agency concerns were resolved. Right? It allows the agencies to get what they want to resolve the antitrust problem, and allows the parties what they want, which is close their deal. And consent decrees are really valuable when the concern is a pretty small part of the overall deal. And I'll give you an example. Say you had a retail fuel station merger. Say you have a company with 1,000 retail fuel stations buying another company that has 100 retail fuel stations. And what the FTC does is they don't look at national market shares. They look at it at a hyper-local level. They'll look at individual fuel stations. Where does each specific fuel station compete against? What other fuel stations? And so they'll basically draw circles around these 1,100 fuel stations to see where the circles overlap. And where they do, and where there are few other competing retail fuel stations, the FTC may ask for a divestiture. They may have concerns. And so in a big transaction like the one I described, where you're acquiring 100 fuel stations, maybe the FTC only has concerns about 3 or 4 of them, right? And so you're willing to just divest the 3 or 4, and then you get to keep your other 96 or 97 and close your deal, relatively smoothly. All right, so that's an example where a consent decree really works well for both sides. And that's historically, again, the way that most deals were resolved when there was a concern by the FTC or DOJ at the end of a second request. Well, and the Biden administration really pulled back from this option. They didn't completely eliminate the consent decree option, but they dramatically scaled it back, especially at the Department of Justice. And so that retail fuel station merger I just described, there's a good chance you would not have the ability to enter into a consent decree. And so you'd either have to fight it out with the DOJ in court, which takes another 6+ months, or abandon your deal. And so we see this sort of this 1-0 approach to merger enforcement during the Biden administration for the most part. And I think we're going to see a return to more historical approach here. I think we're going to see both the FTC and DOJ return to accepting consent decrees, which again is really going to be helpful for those deals where the part of the deal where the FTC or DOJ is concerned with is just a small part of the deal, where the consent decrees really work well for both sides. So I'm cautiously optimistic that we will be able to have that as a realistic option going forward. And that obviously helps parties a lot in the merger planning stages to be able to rely on that possibility down the road. Another thing I think we're likely to see is a return to traditional theories of harm. We saw, very aggressive enforcement during the Biden administration in the sense that they really pushed the envelope in terms of the legal theories, sort of the theories of harm that they pursued. Things like looking at labor markets, looking at interlocking directorates during merger reviews. These were things that we typically don't see a lot of historically. And this was something that really added a lot of uncertainty to the merger review process. People like me trying to advise clients like many of you, it made my job very challenging because it was hard to predict what sort of brand new theory was going to pop up that the FTC or DOJ was going to use to look at a deal that they had not before or had rarely looked at before. So it made it very challenging to predict what deals were going to run into problems and which weren't. One thing I will also say is that Melissa Holyoke, who's the other Republican commissioner, has really hammered this point as well. So both the Chair Ferguson as well as Commissioner Holyoke have said that eliminating or reducing this level of uncertainty for companies who are going through the merger review process is really important to them. So I think this is a really good signal that we may see a pullback of some of the more expansive theories of harm we saw in the last administration that, again, caused a lot of uncertainty for companies going through the merger process. And finally, I think we're going to see a lot of sort of revised policy statements. One thing that Lena Khan did in particular was to issue a lot of new guidelines. So these are, the agencies put out these different enforcement guidelines that basically explain how they view their legal authority to challenge different conduct. So they have guidelines for merger reviews, for competitor collaborations, for something called Section 5 of the FTC Act, which is the underlying statute that governs the FTC. And these were all quite expansive. The new guidelines under Lena Khan, for example, were very expansive, where they just eliminated guidelines and didn't replace them with anything. So I think over time we'll see new guidelines put out that'll reflect a more bipartisan consensus. But again, this will take some time. This is probably like 2 or 3 years into the new administration, I think, before we'll see these. But again, this will, once these are issued, I think will create more certainty for companies going through the merger process, or just to understand exactly what their legal obligations are with respect to the antitrust laws. One final point, I didn't put it in the slides because this is a little bit more speculative. We may see less criminal antitrust enforcement at the Department of Justice. We haven't actually seen any signals from the DOJ to this effect, but what we have seen is that the leadership of the FBI, which actually serves as the investigators in criminal antitrust enforcement, the leadership of the FBI have moved personnel away from white-collar oriented investigations toward other enforcement priorities. And so if that continues, and if that includes antitrust, then it seems very likely that there will be fewer cases generated for DOJ to potentially prosecute. So putting aside, I think I have a slide there. There we go. So in addition to enforcement priorities, any administration has different priorities. There's also a question of how many cases you want to bring. Right? You could actually have a very conservative approach to enforcement, but bring a lot of cases, and vice versa. And so one question is just, how many cases is the Trump administration going to bring? How many merger investigations are they going to bring? And what's the likelihood you're going to wind up, having to fight the DOJ or FTC off in court? You have a merger before them, or they're looking at your conduct for whatever reason. I think the general perception is that the Biden administration was very aggressive and brought a lot of cases. They certainly talked about that a lot. That was certainly the way the media presented that. If you look at the data actually tells a very different story. Enforcement, at least merger enforcement, was way down, actually, well down under the Biden administration versus the first Trump administration. You have the data up there, which is probably quite surprising. And this is a pretty meaningful difference. This is 5 fewer merger enforcement cases brought per year. By merger enforcement cases, I mean, they're bringing a case in court, there's a consent decree, or the parties abandon the deal in the face of a litigation threat. In addition, the Biden administration did not block a single energy deal. Now, they did get some consent decrees on some pretty expansive theories that were probably legally pretty questionable, but they didn't outright block any deals. So I think this is a little bit contrary to I think kind of the prevailing view of what enforcement's been like under the last administration. So I think for folks that are hoping for sort of a retrenchment in enforcement, I don't think that that's likely to happen. I think we're more likely to just sort of see a pretty consistent level of enforcement, or maybe even a slight uptick in the number of cases the FTC or DOJ will bring in the new administration. But again, I think those cases will be based more on sort of more traditional, predictable theories of harm. One final point there, you see that in the final bullet. Oh, and I should also mention in terms of the number of cases, some of you might be thinking, well, maybe it just takes time to sort of build an enforcement portfolio. So maybe the number of cases were small in the beginning of the Biden administration, but then we're ramping up at the end. And it's actually the opposite. There's actually the first 2 years of the Biden administration were the most active, and the last 2 years were the least active. So there was actually a downturn in the number of cases that the Biden administration brought over its 4 years. The last bullet is also sort of interesting. It goes back to the consent decree point I mentioned earlier. In the last 2 years of the Biden administration, only 4 merger investigations were resolved with a consent decree compared to 25 that resulted in litigation or abandonment. That's pretty much a flip-flop of what it would be in any other administration, Republican or Democrat. We typically see far more cases resolved through a consent decree than litigation or the deal going away. So I'm hopeful that we will in fact see a flip-flop of these numbers going forward in the current administration. I think that would be a significant improvement to the merger review process, both for the agencies and for the companies involved. Finally, let me just touch on a couple of other policy developments. That these are sort of holdovers from the prior administration that are still, still very relevant. The first is the FTC's non-compete rule. Almost a year ago, the FTC issued a rule that banned virtually all employee non-competes. There are just some very limited exceptions. This applied, nationwide. It would apply to, new employment contracts as well as existing employment contracts. So very broad scope. This was passed on a partisan basis. Both Republican commissioners dissented. Nevertheless, the rule went into place on a 3-2 vote. A number of lawsuits were filed, and in particular, a couple of cases found the rule to exceed the FTC's authority. Really, the key decision was from the Northern District of Texas, which enjoined the rule on a nationwide basis. The FTC has appealed that. It's now before the Fifth Circuit. But the key here really is that, at least while the litigation is pending, the lower court has enjoined its enforcement. So there's no need to comply with this for now. Again, I think I mentioned earlier, Chair Ferguson, he was against this. He voted against it when it was passed a little less than a year ago, but he doesn't have the votes yet. So again, it's a 2-2 split at the FTC, so he doesn't have the votes to withdraw this rule. So, I'm not sure of the timing of a decision from the Fifth Circuit, but in addition to that action, we may also see, once Mark Meadow is confirmed as an FTC commissioner, the possibility that the FTC could try to withdraw this rule. Another, I think, important development is a new HSR form just went into effect on Monday of this week. Again, this is one of those things that seems like a little bit in the weeds, kind of a beltway thing, and it is, but it is very relevant for companies that are going through, the M&A process, particularly companies that are fairly acquisitive. So since really the late 70s, parties that have a deal that's reportable under the Hart-Scott-Rodino Act have to submit forms. The buyer and the seller have to submit a form to the FTC and DOJ that has a variety of information in it. You put in revenue information, talk about your subsidiaries, your owners, information about the deal, put in some documents about the deal. It's essentially been the same requirements since the late 70s, with a few tweaks here and there. Well, the FTC issued a new rule late last year, which just went into effect this week, which dramatically, and I really do mean dramatically, expands the amount of information and documents the parties have to provide as part of this notification form. And it's particularly on the buyer side. We see a lot more burden. This has been quite controversial within the antitrust bar. Interestingly, the new rule passed on a bipartisan basis. It was a 5-0 vote at the FTC, including the new FTC chair. So this is one area where the new leadership may not make a change, despite this new rule and the new form being quite controversial, at least within DC circles. Interestingly, the new FTC chair just yesterday doubled down on this new regulation, saying it was important that for the FTC and DOJ to have this additional information early in the merger review process. I will say I'm personally a little bit skeptical of that justification. Something like 97% of transactions are cleared by the FTC and DOJ within the first 30 days. So after you do your Hart-Scott filing, the overwhelming majority of deals, the FTC and DOJ conclude very quickly that there's no issue. So for those 97% of deals, there's an awful lot of burden for no obvious return, at least in my view. Now, for the 3% of deals that do raise significant concerns, I could see that these new rules having a real benefit for the FTC and DOJ getting more information earlier on deals they want to take a hard look at. But for the 97% of deals that really are not going to be a problem in the FTC and DOJ's own views, you're adding tens, if not hundreds of billions of dollars of added compliance burden, which seems unjustified. Now, I'm not sure we've seen quite the end of this, even though the new rules have gone into effect just a couple of days ago. So the Chamber of Commerce filed a lawsuit in January seeking to repeal this new rule. Interestingly, the Chamber did not seek a TRO or a PI, so there's really been no activity in the case so far, but it does remain pending. Also, just yesterday, Representative Scott Fitzgerald introduced a bill in Congress to repeal the new rules, which he did under the Congressional Review Act, and that allows Congress to essentially repeal recently issued rules, assuming we can get the House and Senate to agree on that. So that was just introduced, so I don't have a good sense of its prospects, but this remains a live issue. And finally, I guess some good news, early termination is back. So again, just to kind of summarize the process, when you have a deal that's reportable under the Hart-Scott-Rodino Act, both parties have to put in your forms, pay a filing fee, and wait 30 days. And historically, parties could request something called early termination, which meant that if the FTC and DOJ reviewed your deal, and prior to the end of that 30-day waiting period, they concluded that there was no competitive issue, they could send you a letter saying, we're okay with the deal, go ahead and close. So you could shorten your 30-day waiting period down to, 2 or 3 weeks sometimes. Well, at the beginning of the Biden administration, the administration revoked, the FTC and DOJ revoked early termination. So all deals had to wait 30 days, even if the DOJ or FTC concluded the deal was not problematic. That was quite controversial. But the good news is early termination is back as of Monday of this week. And it was actually the previous FTC chair, Lina Khan, that returned to early termination. The idea was to have that come back at the same time the new HSR rules went into effect on Monday. So one bit of positive news there. And with that, I'll send it back to Jason, but feel free to put your questions in the chat. I'm happy to come back to them at the end.
Aaron, there was one question that did show up in the chat I wanted to put to you right now, which is, do you believe that will lobbying the White House prove to be an effective way to either prevent merger challenges or put those in a relief posture like a consent decree? In other words, do we have a view on whether the new agency leadership is going to be as independent as some past agent, as traditionally has been the case?
Yeah, it's a great question. So both agencies historically have viewed themselves as having a fair degree of independence, as almost technocrats. I think that over time, not just in the last administration, but really in the last couple of administrations, I think you've seen both agencies be a little bit more sensitive to the prevailing, sentiments on the Hill and elsewhere in the administration. So I think, in the overwhelming number of cases, probably engaging in a broader government engagement strategy probably isn't going to really move the needle all that much. But I think there are cases, the higher profile cases where you're going to come under a lot of scrutiny. The big energy deals, the big tech deals, big pharma deals. I think having a Hill strategy is really important. And likewise, if there's parties on different sides of a deal, a lot of times there's complainants. There's an industry of people out there that try to raise concerns about transactions, and they can do a lot of damage on the Hill, right? If you have concerns about a transaction, you can raise those concerns directly with the agencies, but it can also be a very effective strategy to go to the Hill, to other groups in the administration and raise concerns. That can elevate the profile of the deal, raise your concerns more publicly, and actually give the agency sometimes political cover to bring the case if they're kind of so inclined already. So I think it really depends on the particular deal in the industry, but I think it is important to consider, sort of broader government House Street strategies, whether you're trying to get a deal through or to block a deal.
Great, thanks. So let's turn to the courthouse. In the year leading up to the election, let's see if I can. In the year leading up to the election, a lot of folks would ask me, if there's a change in the administration, do you expect that there's going to be a change in the amount of antitrust litigation that's going on in the private bar? And certainly, we are talking about an area where there are federal statutes that are binding. The pre-clearance process gives the federal enforcers a lot of natural leadership role on deal flow. It gives them a lot of natural leadership role in the ability to issue guidance that courts will find persuasive. So no question, the administration is certainly at the headwaters of a lot of antitrust activity. But remember, the federal agencies don't stand alone by any stretch of the imagination. In enforcing antitrust law, the Sherman Act itself gives state attorneys general a lot of opportunity to bring cases under the federal law. They can seek injunctions to prevent wrongful conduct. They can seek damages on behalf of their citizens. And each of these state AGs also has their own state antitrust law that they can enforce. So a change in the administration doesn't necessarily portend there's going to be a change among the 50 other sovereignties that we have in this country. And of course, federal and state antitrust law both provide for private rights of action, which can be pursued in courts all over the country. So it's never just a question of whether the White House is red or blue, because the State House and the courthouse have their own colors as well. The other thing that I think this transition is really going to bring out is how adaptable a tool antitrust law is. After all, this is a body of law that involves courts in policing market outcomes. And it turns out that people can critique market outcomes from the left and the right and the center and everywhere in between. You have lots of complaints that can come from producers or from buyers, from sellers or from consumers, blue states or red states. And a lot of those cases have been plodding along for a long time, and they'll continue to plod along. And you will not, it's going to be a leading indicator with a lot of lagging outcomes. It's not necessarily something that's going to just flip a switch and things will change. This is, after all, a tool that invites people to go to court and say, I don't like the outcomes the market is producing, and I think it's because there's some sort of anti-competitive conspiracy going on. So it's really not a question, is it a red tool or a blue tool? It is a tool, and anybody can pick it up. So let's talk about how that tool has been used the most of late and how it is reaching the energy and chemicals sectors in particular. The hottest topic in antitrust over the last few years has been pricing. The sort of Moneyball mentality, the trading desk mentality of mining data to get good insights about markets has been really influential over the last 20 years. There's been an explosion in data analytics services and data analytics personnel who advise on pricing and talk about how companies ought to be adjusting to try to grow the market. It's had a lot of benefit in improving our understanding of the way markets work, but in many industries, the data analytics is primarily being done by outside services, and in some cases, there will be, one or a very few number of services that are doing most of the data analytics work. And in private litigation, we've seen the argument that these services are now gathering so much data on prices and are so influential among all the different players in the marketplace that they're employing algorithms that recommend prices to so many people in the market that it essentially becomes a tool for facilitating price fixing. And that's happened in industries like apartment complexes, poultry, turkey, RV parks, what have you. It's just been kind of going industry by industry where the plaintiff's lawyers find there are data publishers or data consulting services that are influencing pricing. They're looking at the possibility of bringing lawsuits. So we've seen lots of cases, and there's been a lot of activity. One new case in this vein that's touching our particular sector here is the PVC pipe litigation. The contention here is that all the chemical companies that make PVC pipes, they're called converters, that all the PVC converters subscribe to the same publications, Opus. And the plaintiffs contend that the data in Opus was too detailed, and it crossed the line from just reporting on past price activity. It crossed the line into giving guidance to the readers on what prices ought to be in the future and how the different converters might conduct themselves going forward. So it allegedly became a way for converters to signal to one another and coordinate their prices for the PVC pipe they were placing in the market. The case is still in its early days, but I think it's a reminder to check in with your people who interface with the publishers, the price reporting services, and who use outside data analytics firms, and make sure they're being careful about what they say and how they conduct themselves in dealing with those outlets. Opus, of course, is a very important service reporting on energy and chemical commodities, so we shouldn't expect that these kinds of inquiries will be limited to just this PVC case. We'll probably hear more about these kinds of claims in the future. Another hot topic that's crossing over into the antitrust space in our world is ESG investing. And here, this is an example of how antitrust actions can really be deployed from any political vantage point. The case that I want to talk about here is Texas versus BlackRock, and I'll disclose that we're involved on the defense side in this case. But it's a case brought by 13 state attorneys general against the three biggest asset managers in the country, BlackRock, Vanguard, and State Street. These companies manage investment portfolios, mutual funds, exchange-traded funds, and the like. And just like other asset managers, they offer a variety of index funds. So if you as an investor want to invest in the entire S&P 500 or some other index, managers like this can give you that opportunity. And they form funds that buy shares in every publicly traded company in whatever index they're tracking. Now, about 10 years ago, it became popular among a specific set of economists to argue that these index funds were having an anti-competitive impact. The theory was, just for an example, if all the airlines have overlapping shareholders, well then, United won't compete hard against Delta because they say, well, our shareholders are also Delta's shareholders, and 25% of my shares are owned by the same index funds that are owned that own Delta. So I shouldn't compete hard, and we should all raise our prices and we'll behave like monopolists. Well, there were a lot of articles that were written about that idea, and it was sort of briefly in vogue among certain political intelligentsia, but there weren't very many cases that were brought under this theory because I think the theory just didn't really make sense at the end of the day. Yes, the index funds might be involved in investing in multiple airlines, and theoretically, yes, if someone owns shares in multiple airlines, they want all the airline industry to do well rather than having them compete hard against one another. But the reality is, if you own an index fund, you also are invested in companies that buy airline tickets, and they want plentiful, cheap airline fares. And you're also invested in hotel companies who want lots of air travelers going to different destinations around the country. And you're also invested in manufacturers who sell equipment to airlines. And you don't want stagnant airlines who don't compete. You want airlines that are trying to upgrade their physical fleet and compete on the basis of having the best consumer proposition. So when you're invested in the whole economy, the idea that you're happy with little monopolies in different segments of the economy that are creating dead weight economic loss, it just doesn't really make a lot of sense. So the theory generated a lot of academic interest. There were a lot of articles that were written. It did not result in a lot of lawsuits. But we got this new lawsuit here. In this new lawsuit, the states are alleging that the big asset managers own shares in multiple coal companies, and that could cause the coal companies to act like monopolists and reduce coal production and raise coal prices. And the states claim this would be likely to happen if asset managers or coal companies ever express any concern about climate change. And that's what the case is really about. The 13 AGs who are bringing the case are red state AGs who have announced broad inquiries and enforcement priorities opposing ESG policies. And their argument is that if companies ever talk about ESG issues, maybe it's because of an antitrust conspiracy. Well, no matter how you feel about ESG policies, this is problematic as an antitrust theory because it really doesn't have any boundary around the concept. You can take the theory to any industry you want to. Anytime prices go up in any industry, whatever it might be, cereal, the cost of gasoline, the cost of an airline fare, if it's a supply shock, if it's a cost increase, if it's a demand growth, whatever is causing the entire industry's price to move, you could always say, all these big players have got overlapping shareholders because the index funds own big shares of all big companies. And courts have always been very thoughtful to say that it's not enough to show the market moved. It's not enough to show that all the big players are raising or lowering prices when they're responding to common economic phenomena. You have to allege facts that really show a conspiracy was the reason that the market moved the way that it did. If the presence of overlapping shareholders is going to be enough to count as a reason to assume that there's a conspiracy, you can imagine plaintiffs using this theory just on any industry, anytime prices move. So I think it's a potentially dangerous theory. I think it's a shame that it's being advanced by these state AGs, but the case is just getting started. We'll see where it goes. It will be one to watch in the year at least a year ahead, and maybe for longer than that. Next, I want to talk about shale oil. If we could advance to the next slide, please. It's another important case that started in 2024. It's the NRA shale oil antitrust litigation. Again, we're on the defense side of this case. The allegation is that the major independent shale producers must have agreed to coordinate their production decisions with OPEC. The case sprang out of an article alleging that U.S. producers met with the OPEC Secretary General here in Houston during Syria Week a couple of years ago. A number of cases have been filed with putative classes of direct purchasers, like refiners, and indirect purchasers, like gasoline consumers. Those cases have now been consolidated into a multi-district litigation in New Mexico in federal court. And is often the case for these big antitrust matters, the process of getting these cases consolidated, getting them into a place where a common complaint can be filed, and responses can be framed for it by the defense group as a whole. It can take a while to get all that going. So it's taking a good deal of time, but they'll start getting into the substance of these allegations and testing the substance of those allegations later this year. This case is distinct from, but it reminds me of a case that came out. It was decided this year. It's the D'Augusta versus API case. There's some overlap in the subject matter. In API, the plaintiffs were alleging that the big shale producers had all lobbied the first Trump administration to intervene in the Russia-Saudi price war. You might remember back in March of 2020, Russia and Saudi Arabia were going back and forth with massive production announcements, driving the price of oil just into the ground. And many thought, me included, this was a calculated effort to make the U.S. shale production industry just completely non-economic. There were a number of shale producers who went to the White House to say just that, and you might remember that after a few weeks, the price war finally came to an end. Russia and Saudi Arabia started getting back to normal, and the president tweeted out some comments suggesting he'd helped bring the price war to an end. But while this was all going on, shale producers were doing what shale producers would normally do during a time of low price. They were cutting their production. So there were plaintiffs who alleged this was all part of a conspiracy, and that shale producers had gotten Donald Trump to broker a deal with OPEC Plus to cut supply and raise prices. The district court dismissed the complaint, and in 2024, the Ninth Circuit affirmed the dismissal. The conclusion that the Ninth Circuit reached was, let's just take the complaint as true. Let's just credit these allegations for what they say. If the White House actually had brokered a deal with foreign nations, then the courts shouldn't get to intrude on that. It would be a foreign policy decision. It would be a deal that would be immune from court challenge under the political question doctrine, the active state doctrine. And if the producers really had banded together to ask the White House to make that deal, well, that would be political activity. It'd be protected under the First Amendment. In the antitrust world, we call that Noer-Pennington immunity. So those cases are over now, and I don't think we'll get that kind of case back, but we may get something like it with the notion of some sort of direct coordination rather than alleged coordination through political activity. Next, I want to talk about a couple of interesting cases in the power sector. Antitrust is always interesting in power because you're frequently dealing with mixed markets. With transmission providers or utilities, you frequently have regulated monopolies that have been in place for a long time, and they interface with markets that either are competitive or are becoming competitive, like power generation, having to connect to existing regulated monopoly structures. It's a lot like the old AT&T breakup, where you have the old providers that are interfacing with utilities or monopolies. The Duke Energy Carolinas case is probably the most significant just antitrust hardcore case law out of the years, a Fourth Circuit case. NTE was building gas-fired power plants in North Carolina and wanted to sell power to a utility in Fayetteville. And as a new power producer, they needed to connect to the existing transmission network, which was owned by Duke, and the interconnect was contentious, but after a while, the thing kind of fell apart. NTE defaulted on their interconnect agreement. Duke sued NTE to recover the overdue payments, and NTE said, look, the reason we defaulted on our interconnect, the reason we didn't pay you is because we couldn't build the power plant in Fayetteville, and the reason we couldn't build the power plant in Fayetteville was because you underpriced us and you started generating the power that Fayetteville bought. And so they alleged that Duke was essentially monopolizing or extending its monopoly from transmission into the power generation space as well. The district court had dismissed this claim on summary judgment, said that Duke hadn't engaged in predatory pricing, but the Fourth Circuit last year reversed that decision. The appeals court said there was at least a fact dispute on whether Duke had engaged in predatory pricing on the power generation piece of this. Now, Duke had argued that we're in a filed rate environment. We send our rates to FERC, FERC approves them, and basically our rates ought to be immune from antitrust challenge for that reason. The Fourth Circuit said the FERC review is neither here nor there because FERC's not reviewing filed rates to make sure that they're protecting competition between power generators. They're just reviewing the filed rates to protect the ratepayer, to make sure that there hasn't been a discrimination in favor of some ratepayers over others. So when NTE argued that Duke had made a non-economic price available to the Fayetteville power plant to drive NTE out of business, Duke could not use FERC review as a way to immunize themselves from that claim. So that case is being remanded for trial, and we'll see what happens with that perhaps over the next 12 to 18 months. There's the Hawaiian Electric case. This is an interesting case on antitrust injury. You had a case involving a biopower startup that had signed an agreement to sell power to Hawaiian Electric, but the startup's plant construction was repeatedly delayed. They eventually got to a deal where the startup and Hawaiian Electric were going to enter into a power purchase agreement as long as the PUC approved the deal, and the PUC did not approve the deal. So the startup sues Hawaiian Electric saying, hey, we wouldn't have been in this mess if you had made a deal with us on fair terms, and the reason you didn't deal with us on fair terms is because you wanted the generation business rather than us doing our new biopower plant. So the district court disagreed with that conclusion and said, your injury is you can't sell power. And that injury is not because of anything the utility did, it's because the PUC didn't like your plant. And it was a case where the PUC had said that the emissions from this new plant were going to be excessive. And they did a very good job, I think, of tracing what the factual cause of the alleged injury were. There's a couple of new cases in New England and Pennsylvania where you've got utilities that are being alleged to block new power generators from coming into their space. Pretty factual, specific issues. But a Canadian hydroelectric producer in the New England case, you've got a small utility supposedly stonewalling sign-ups. In the Pennsylvania case, looks a lot like old phone company cases. Both new cases, we'll see what happens, but I think we're going to see a lot of interest in, as we go forward, in power companies challenging whether incumbents are preventing them from getting into the space. So Darren, you got any other questions you've heard from the group so far?
I am not happy to take any other questions. And also, I just want to shout out to Billy Vigdor. The earlier question came from Billy. I didn't realize at the time. Billy is a retired V&E partner, so really glad you could join us, Billy. We definitely miss you around here.
Okay, if there are no other questions right now, you can certainly talk to us afterwards, but that's the year of antitrust in the energy business. Love to talk to you more about any of these issues, so just find us on the web, call us on the phone. Happy to visit with you more, but we're glad you came to visit with us today, and we look forward to seeing you at the next Energy Industry Series CLE.